Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we are diving into a major development in the UK's criminal justice system, a reform proposal announced by the government last year and now materialising. Of course, I'm talking about the court system and jury trials. According to a press release dated the 2nd of December titled "Swift and Fair Plan to Get Justice for Victims," the aim is to put victims first, modernise the criminal courts and cut delays. On the surface, that sounds entirely reasonable. We all agree that victims deserve timely justice, and that the criminal justice system backlog is a serious problem. But underneath that messaging lies a much bigger, much more fundamental question. What is the purpose of a criminal trial? Is it to give justice to victims? Or is it to prevent the punishment of the innocent? Because depending on your answer, the consequences for how we design trials, including whether we use juries, are enormous. And today, I want to unpack what the government is proposing, why they say this will help, and why I think we are on the verge of making a very serious mistake. And I'm not the only one. Let's start with what the reforms actually involve. The government's proposal introduces a set of changes aimed at reducing the backlog of cases clogging up the Crown Courts. Among these changes are 1. The creation of swift courts. This would be judge-only trials without a jury for cases expected to attract sentences of up to 3 years. In fact, according to earlier leaks, the government's original plans seem to have been even more extreme, with an initial sentence limit of 5 years. After the leak, however, the government apparently felt compelled to revisit the proposal and reduce it to 3 years. Perhaps we're meant to feel grateful for that timely reversal. So, in addition to the swift courts, a limit on the defendant's right to elect a jury trial. In many cases, the choice between jury trial and judge-only trial will no longer sit with the defendant at all. It will be determined by the court. 3. An expansion of sentencing powers granted to magistrates. This shifts more cases away from the Crown Court system entirely. 4. Potential judge-only trials for complex cases. Now, the proposals say that complex cases will still remain tried by juries. However, there is an exclusion for technically complicated cases like large fraud trials or intricate financial matters. The government argues that these reforms will speed up justice significantly. Well, to be fair, judge-only trials tend to run faster. They don't require jury selection, they don't pose for jury directions, and legal arguments that would normally be heard in the jury's absence can be handled more efficiently. And also, to be fair, we do have a large backlog. Crown Court delays have grown year after year, and many victims are waiting months, sometimes even years, to see an outcome. So yes, so far the government has told us the truth. The problem is real. But the solution the government is proposing fundamentally changes what it means to be tried in this country. And before we decide whether speeding things up is worth it, we need to talk about the principles at stake. First, it's worth noting that the very individuals now promoting these proposals were once strongly opposed to the idea.
The Justice Secretary's plans to curb jury trials is the Justice Secretary himself. In 2020, he said, criminal trials without juries are a bad idea. You don't fix the backlog with trials that are widely perceived as unfair. In 2017, in his report into prejudice in the criminal justice system, he found juries, and I quote, act as a filter for prejudice. But now he's become Justice Secretary, he's scrapping the very institution he once lauded. Which is it? Will the real David Lammy please stand up? And what about this? There should be a right to trial by jury in all criminal cases. Any ideas, Mr. Speaker? Who else? It's the Prime Minister this time.
These alone should serve as a major red flag. But we should go further. And here is where the government's messaging becomes deeply misleading. In the press release, the central claim is that victims must be put first. And while that sentiment sounds compassionate, it completely misstates the purpose of a criminal trial. A criminal trial is not primarily about giving justice to victims. It is about making sure the state does not punish an innocent person. Of course we care about victims. Of course we want them to see justice served. But the trial itself is not designed to prioritize victim satisfaction. It is designed to test the evidence against the accused. If the purpose of a trial were truly to put victims first, then we wouldn't need trials at all. We would simply trust the police investigation and convict the accused as soon as the file landed on the prosecutor's desk. But we don't do that. And why not? Because we recognize the terrible power of the state to destroy someone's life, whether through negligence or even malice at times. Our system has always embraced the principle expressed best by William Blackstone. It is better that 10 guilty persons escape than that one innocent suffer. This is not a slogan. This is the foundation of a free society. So when reforms are introduced in the name of victims first, we need to be extremely careful, because whenever we shift the focus away from protecting the innocent, you inevitably increase the risk of wrongful convictions. Now, let's talk directly about juries, because this is the real heart of the reform. Jury trials are not perfect. They can be slow, they can be expensive, and yes, sometimes jurors can misunderstand complex evidence. But jury trials are also one of the strongest safeguards we have against injustice. Here is why they matter. Juries prevent a single judge from having total control over the fate of the accused. Juries ensure that justice is not just technical or legalistic, but aligned with the conscience of ordinary people. When 12 citizens have to be convinced, the prosecution must actually prove its case, not merely tell a plausible story. Judges are trained professionals who spend their lives immersed in the system. Juries bring an outside perspective. And sometimes that perspective is exactly what prevents miscarriages of justice. These protections disappear in a judge-only trial. When you remove the jury, you concentrate power. And whenever you concentrate power, you increase the risk of error or abuse. Now, let's address the elephant in the room. Will cutting jury trials actually reduce the backlog? The government says yes. However, critics, including many legal professionals, say no. Here is why critics are skeptical. The backlog is overwhelmingly caused by lack of resources. According to the Institute for Government website, key contributors to law productivity in courts include high workloads, staff shortages and inexperience, poor court administration, crumbling buildings, problems with technology, not by the presence of juries. If these problems can be adequately addressed, many of the proposals for radical reform in the courts will not be necessary. We don't have enough judges, enough court staff, or enough functioning courtrooms. Years of underfunding have led to broken infrastructure, cases being cancelled, and courts running far below capacity. Removing juries does nothing to address these underlying issues. 2. Judge-only trials can actually raise new legal challenges. When one person handles both fact and law, appeals become more complex. 3. The pressure on magistrates. These could create errors earlier in the process. Giving magistrates greater sentencing power shifts cases into a system already stretched thin and with far fewer procedural safeguards. During a parliamentary debate on the 8th of December, Andy Slaughter, chair of the Justice Committee, raised a crucial point.
Justice Select Committee, Andy Slaughter.
Thank you very much, Mr. Speaker. There's no reason why the government should not consider mode of trial as part of its reform of the criminal courts, but they would find more support if they could better evidence the effect of these changes. To what extent will the proposed changes to jury trial reduce the backlog? What proportion of cases, proportion and type of cases, will no longer be eligible for jury trial? And if courts are going to be swifter and have greater sentencing powers, what effect will this have on the prison population?
I'm grateful to the Chair of the Justice Select Committee for his reflection that mode of trial is something worth looking at. Of course, the government will be providing an impact assessment when it brings forward the necessary legislation that will need to accompany these reforms. But I would suggest to him that we do have an evidence base. The evidence base is that provided to us by the independent review of the criminal courts. We also have the very real evidence base that at the moment, the kinds of offences that we are talking about, the kinds of offences that we are talking about are those triable either way offences. Not summary only, already dealt with in the magistrates' court, not those indictable only offences which will always have a jury trial in our Crown Court, but triable either way offences. And at the moment, you can either opt for a magistrates' trial or you can opt for a Crown Court trial. And what we know is that where defendants opt for a magistrates' trial, those are being heard 4 times faster on average than that when they're heard in the Crown. That is a pretty strong evidence base coupled with that of the IRCC. So, of course, we will need to present the impact assessment of the particular package that we are bringing forward. But there is no doubt that this government is taking action on an evidential basis that we have been provided by through an independent review.
But shouldn't such an assessment have been carried out before the proposal was put forward? Has the government effectively reversed the proper process? And if so, can we really be confident that these reforms have been fully thought through? So, if these reforms don't meaningfully fix the backlog, what are they doing? Essentially, they are permanently changing the structure of criminal justice. And once jury trials are taken away, they are unlikely to be restored in future. And this brings us to the philosophical heart of the issue. Do we value justice more than speed? Because justice is not simply a matter of getting to a verdict quickly. Justice is about arriving at the right verdict. A fast wrongful conviction is far worse than a slow correct one. A hastily system is not a fair system. And if reformers genuinely cared about victims, they would understand that victims themselves have an interest in a just, reliable verdict, not merely a rapid one. So let's sum this up. The government is proposing to cut back jury trials in the name of efficiency and to put victims first. But the purpose of a criminal trial is and must always remain to protect the innocent from wrongful punishment. Juries are vital safeguards, a democratic check on state power, and a crucial part of public trust in justice. Yes, we need to fix the backlog. Yes, victims deserve timely justice, but we cannot fix delay by weakening fairness. And we cannot claim to be protecting victims if our solution is to erode the very principles that keep innocent people safe. Real reform requires investment. It requires more judges, more court staff, more functioning courtrooms. It does not require dismantling one of the core pillars of British justice. If you have made it this far, thank you for watching. I would genuinely love to hear your thoughts on this. Do you think judge-only trials are a necessary step? Or is this a dangerous erosion of fairness? Let me know in the comments below. Please consider liking and sharing this video and subscribing to our channel for more discussions on matters that impact our criminal justice system. Join us again as we sit and rise in this unique trial.